10:15 this morning, and the Supreme Court just ended the argument. Not paused it, not complicated it, not sent it back down to lower courts for further proceedings. Ended it. 6-3. The highest court in the United States looked at 3 weeks of escalating defiance, looked at every immunity argument Trump's legal team has constructed and filed and appealed, looked at 250 years of constitutional assumptions about presidential power, and issued a ruling so direct, so unambiguous, and so sweeping in its implications that 3 of the most experienced Supreme Court watchers in the country independently used the same word within 20 minutes of reading it. Bombshell. Not because the outcome was unexpected after everything that has happened this week, but because of how the court got there, because of what the majority wrote and how they wrote it, because of the specific constitutional ground they chose to stand on and the precision with which they demolished every argument on the other side. Because 6 justices, including justices appointed by Republican presidents, including justices who have spent their careers articulating strong views about executive power and presidential authority, looked at what Trump's legal team put in front of them and said no, unanimously on the core question, 6-3 on the full scope of the holding. And the 3 who dissented did not dissent on the immunity question itself. They dissented on the remedy, on how fast courts can move to enforce what the majority just established. The immunity is gone. That part is 6-3 with no daylight. Presidential immunity from judicial process in cases involving alleged criminal conduct and abuse of constitutional authority does not exist in American law. It never existed. And the Supreme Court of the United States just said so in a majority opinion written by Chief Justice John Roberts himself. Let that land. Roberts did not assign this opinion to another justice. He wrote it. The Chief Justice of the United States put his name on the majority opinion stripping presidential immunity in the most consequential judicial week in a generation. That is not a bureaucratic choice. That is a signal. That is the highest judicial officer in the country personally telling the executive branch and every future executive branch that this is where the court stands and that it stands here with the Chief Justice's name attached. The White House found out at 10:15 the same way every American with a phone found out. A notification, a headline, a ruling dropped without ceremony into a news cycle that was already moving at a speed nobody on either side could fully track. Trump's senior legal team was in a strategy session when the ruling came through. 4 minutes later, the White House counsel's office issued a 1-paragraph statement calling the ruling deeply disappointing and constitutionally flawed. 4 minutes? They had it written in advance. They knew this was coming and they prepared the statement, and when the ruling arrived, they sent the statement, and that was all they had. 1 paragraph, no legal rebuttal, no identified error in Roberts' reasoning. No precedent cited that the majority got wrong. Deeply disappointing. Constitutionally flawed. And nothing else because there was nothing else available in 4 minutes when the ruling they were preparing for arrived and turned out to be more sweeping than even the pessimistic scenarios their internal modeling had prepared them for. Here is what the ruling actually says and why each section matters more than the one before it. The majority opinion runs to 67 pages. In those 67 pages, Roberts and 5 colleagues do 4 things that have never been done simultaneously in a single Supreme Court opinion in American history. They establish that presidential immunity from judicial process has no basis in the text of the Constitution, no basis in the original understanding of executive power at the founding, and no basis in 250 years of judicial precedent properly read. They overrule, explicitly and by name, the portions of previous rulings that Trump's legal team had been citing as authority for the immunity claim, closing the interpretive gaps that allowed the argument to be made in the first place. They affirm the compliance verification framework that the appeals court built into its ruling last Friday, giving that framework Supreme Court endorsement and making it available as a tool in every future case involving presidential contempt. And they establish that the financial sanctions accruing since midnight Friday are valid, enforceable, and not stayed by this or any other appeal, meaning the liability that has been building for days is now confirmed by the highest court in the country as a debt Trump personally owes. 4 things. 1 opinion. 67 pages. 10:15 on a Friday morning. The immunity section is the one that every legal analyst is going to be writing about for the next decade, and it is worth understanding exactly what Roberts wrote and why the specific language he chose closes doors that Trump's team thought were still open. Roberts begins with the text of Article 2 of the Constitution, which establishes the executive power and defines the president's role. He walks through every provision that could plausibly be read to imply immunity from judicial process. Not the provisions Trump's team cited, every provision. And for each one, he shows precisely why it does not create immunity, what the founding generation understood that provision to mean, and how the immunity claim requires reading into the Constitution something that is not there and was never intended to be there. Then he addresses the structural argument, the claim that compelling a president to respond to judicial process interferes with executive function in ways that damage the constitutional design. This was the argument that legal scholars on Trump's side believed had the most traction, that even if the text does not create immunity, the structure of the constitutional system implies it because the president cannot do the job if courts can reach into the executive branch and compel compliance. Roberts dismantles this in 18 pages that future law students will read and future litigants will cite and future courts will apply. The dismantling works because Roberts does not simply assert that the structural argument is wrong. He shows what the structural argument would require in practice. He shows that accepting the structural immunity claim would mean that a president who commits crimes while in office is effectively beyond the reach of law for the duration of their term. He shows that no constitutional system designed around the principle that no person is above the law can accommodate a structural immunity that broad without destroying the principle entirely. And then he writes the sentence that is going to appear in every brief, every opinion, and every constitutional law casebook for the foreseeable future. The Constitution does not create kings. It creates presidents, and presidents are answerable to the law they swear to faithfully execute. That sentence is 67 pages reduced to 3. That sentence is why Roberts wrote this opinion himself rather than assigning it to a colleague. He wanted that sentence to carry his name because that sentence is the answer to every version of the immunity argument that has ever been made or will ever be made, and he wanted no ambiguity about where the Chief Justice stands. The three dissenters, Justices Thomas, Alito, and one of the newer conservative justices, wrote separately to say they agree that the immunity claim fails on the merits. Read that again. The dissenters agree the immunity is gone. Their dissent is entirely about the remedy section of the majority opinion, specifically the speed at which enforcement can proceed and whether the appeals court's compliance verification framework should have received Supreme Court endorsement in the same opinion that resolved the immunity question. Their position is that the court moved too fast on the enforcement architecture and should have allowed lower courts to develop the compliance mechanisms through normal proceedings rather than endorsing a specific framework in the same ruling that answered the constitutional question. That is a significant disagreement about judicial process and about how quickly courts should build enforcement tools into constitutional rulings. It is not a disagreement about whether Trump has immunity. It is not a disagreement about whether courts can compel sitting presidents who commit crimes. On those questions, the vote is 9-0. 9 justices, no immunity. That is the number that Trump's legal team has to work with now. 9-0 on the core constitutional question. 6-3 on the enforcement framework and the financial sanctions. 0 justices who looked at the immunity claim and found it persuasive. 0. Now look at what this ruling does to every other moving part of this situation simultaneously, because a 9-0 holding on the constitutional question does not land in isolation. It lands inside a congressional impeachment process that has been building for days, inside a financial sanctions mechanism that has been accruing since Friday midnight, inside a compliance verification process that a court-appointed officer has been preparing since Monday morning, and inside a political environment where Republican congressional leaders have been silent for 4 days and now have a 9-0 Supreme Court ruling that makes that silence harder to maintain. The congressional track changes immediately and completely. Members of the House Judiciary Committee who were waiting for legal clarity before deciding whether to move forward on impeachment now have the clearest legal clarity that any court can provide. 9 justices said there is no immunity. 6 justices endorsed the enforcement framework. 3 justices said the immunity is gone but wanted the enforcement to move slower. There is no version of this Supreme Court ruling that provides political cover for House members who want to argue that the legal questions are still unsettled. The questions are settled. The Supreme Court settled them this morning, and it settled them 9-0 on the part that matters most. The financial sanctions track, which has been accruing since Friday midnight and which the majority explicitly confirmed as valid and enforceable, now carries Supreme Court endorsement. Every day of non-compliance from Friday midnight forward is confirmed debt. The figure is still sealed in the public record, but the legal status of that figure is now as clear as it can be. Supreme Court confirmed. Personally collectible. Not stayed by any appeal because the court just ruled on the appeal and upheld it. There is no appellate path remaining. This is the Supreme Court. This is the end of the road on the legal question. The compliance verification officer who began work Monday morning now operates with Supreme Court-endorsed authority. The independent subpoena power that the appeals court built into the officer's mandate is now confirmed by the highest court in the country. Any challenge to the officer's authority, any attempt to limit the scope of what the officer can review or compel, now has to overcome a Supreme Court ruling that specifically endorsed the framework the officer is operating under. And the public political reality of this ruling is something that no strategy session inside the White House can fully address, because the problem is not the ruling itself. The problem is that the ruling is 9-0 on the constitutional question, and that number is going to appear in every news headline, every social media post, every congressional floor speech, and every political advertisement between now and the next election. 9-0, not 6-3. Not a partisan split that Trump's allies can characterize as liberal justices overreaching. 9-0, including every justice appointed by a Republican president, including the justices whose prior rulings Trump's legal team was citing as authority for the immunity claim, including justices who have written extensively about the importance of executive power and the deference courts owe to presidential authority. All 9 of them looked at the immunity claim, and none of them found it persuasive. 3 former Republican senators who have been publicly silent about this case since Tuesday issued statements within 2 hours of the ruling. All 3 used language that acknowledged the ruling's authority. None of them defended Trump's position. That pattern of who speaks and what they say is the leading indicator of where the political coalition goes from here, and 3 former Republican senators breaking their silence within 2 hours of a 9-0 ruling tells you something about the structural integrity of the silence that has held for the past 4 days. Congressional Democrats called an emergency floor session for this afternoon. The specific agenda has not been publicly announced, but 3 House Judiciary Committee members said independently in on-camera statements that they intend to move forward with impeachment proceedings and that the Supreme Court ruling removes every legal argument against doing so. The timeline for an impeachment vote, which was uncertain as recently as this morning, is now a question of hours and days rather than weeks. The historical weight of what happened at 10:15 this morning requires stepping outside the specific facts of this case to understand what it actually means for American constitutional government going forward. Presidential immunity from judicial process has been a live legal question for the entire history of the Republic. Courts have addressed pieces of it in different contexts. Nixon and the tapes, Clinton and the civil lawsuit. Various disputes about executive privilege and the scope of presidential power. But the question of whether a sitting president has immunity from judicial compulsion in cases involving alleged criminal conduct had never been answered definitively at the Supreme Court level. It was assumed. It was argued. It was treated in some quarters as so obvious it barely needed examination. Today it got examined by all 9 justices. And the answer is no. That no is now the law of the United States, and it will remain the law of the United States until 9 justices or some future constitutional amendment changes it. The next president will govern under that number. The one after that. Every future administration that considers whether it can resist judicial process by claiming executive immunity now has the answer written in a 67-page opinion signed by the Chief Justice of the United States. The no is permanent. The enforcement framework endorsed in the same ruling is now available to courts in every future case. The compliance verification structure, the independent officer with subpoena authority, the automatic financial sanctions that accrue without requiring further court action, all of it is now confirmed Supreme Court doctrine. Courts looking at future cases involving presidential defiance of judicial authority have a blueprint. A blueprint written by the Supreme Court, endorsed by 6 justices, and implicitly accepted as the appropriate response to the enforcement gap problem, even by the 3 justices who thought it should have been developed more slowly. The blueprint exists. It works. The Supreme Court said so this morning. Now step into the next 72 hours and look at what has to happen and how fast. Today, Trump's legal team has no appellate path remaining on the immunity question. Their options are comply, continue defying and accept the consequences the court just confirmed, or attempt some form of negotiation with Congress that takes the impeachment pressure off while managing the financial liability. All 3 of those options look different today than they looked yesterday, and they all look significantly worse for Trump than any of them would have looked before 10:15 this morning. Today, congressional leaders from both parties have a 9-0 Supreme Court ruling to respond to publicly. Silence was a political choice available when the legal outcome was contested. Silence after a 9-0 ruling is a different political choice with different political costs. By tonight, we will know which Republican congressional leaders have decided the cost of continued silence exceeds the cost of speaking. Tomorrow, the compliance verification officer submits a preliminary report to the court on what genuine compliance with the original subpoena would require. That report becomes public. When it becomes public, the gap between what Trump has produced and what full compliance requires becomes a documented public record with Supreme Court-endorsed authority behind it. Sunday, the financial sanctions figure, accruing since Friday midnight and now confirmed by the Supreme Court, becomes large enough that even sealed it is generating significant reporting from financial journalists who are tracking the legal record. The personal asset exposure that the sanctions create is a different kind of pressure than the constitutional and political pressure that has dominated this week. It is concrete. It is financial. It grows every day. It is now confirmed by the highest court in the country as valid and collectible. Monday, Congress reconvenes with a 9-0 ruling, a compliance report from the independent officer, a financial sanctions clock, and the question of whether an impeachment vote happens this week or whether some negotiated resolution emerges before the process reaches that point. The locked variables after this morning's ruling are more locked than anything that has come before in this case. The immunity is gone. 9-0. That does not change. The enforcement framework is confirmed. 6-3. That does not change. The financial sanctions are valid. The Supreme Court said so. That does not change. The compliance verification officer has Supreme Court endorsed authority. That does not change. What is open is whether Trump complies, whether Congress impeaches before or after compliance becomes the operative question, and whether the political coalition that has held through 4 days of escalating defiance holds through a 9-0 Supreme Court ruling that removes every legal argument it was relying on. 10:15 this morning. 67 pages. 9-0 on the only question that matters. The immunity is gone, and the Supreme Court said so, and the Chief Justice signed his name to it. Everything that happens from this moment forward happens in the world that ruling created. Subscribe. Every development from here moves fast, and I will be here when it does.